Hello, my name is Cristina Tebar Less. I'm a lawyer. I'm specialized in environmental and international law, and I have worked on sustainability issues for many years. The laws and regulations around sustainable finance that exist today have been based primarily on voluntary standards and so-called soft law. This pattern applies not only to the financial sector, but also to other sectors. Overall, the integration of sustainability considerations into business operations or corporate social responsibility (CSR) started as a voluntary move, but over the past years, voluntary standards have been embedded into binding regulation or so-called hard law. This trend, of course, varies depending on the countries, and some governments have been more proactive in embedding sustainability factors into legislation than others. The European Union has been a key driver in rendering the integration of sustainability criteria mandatory for business, including through its Sustainable Finance Action Plan. In this video, I will first elaborate on the meaning, role and power of soft law, and then briefly describe a few voluntary norms and incentives that have found their way into hard law. I will begin with the definition. The term soft law refers vaguely to non-binding provisions, or provisions whose breach does not entail legal consequences, such as fines or other pecuniary sanctions, or the withdrawal of an authorization or a license. However, though not binding, the power of soft law should not be underestimated, in the same way as the power of hard law or formal legislation should not be overestimated. Here are a few key features of soft law. Soft law often starts as self-regulation, whereby a group of leaders agree to set themselves certain standards of behavior, benchmark, and compare the performance. This approach helps drive collective action and break the inertia of being the first mover. I do it if you do it. Soft law sends important signals about what society at large expects from business. When this expectation is made public by key market players, for example institutional investors or by governments, it is difficult for companies to ignore those signals and to continue doing business as usual. These signals also generate peer pressure. They are an incentive to emulate others and create a competition to the top. And finally, soft law does not remain static. It keeps evolving in line with changing expectations, and in many cases, eventually turns into binding regulation. One well-known adage is that soft law of today is a hard law of tomorrow. Let's now look at a few examples to illustrate how soft law drives responsible finance. I will talk about 3 of them. They are just a few among many, and I have selected them to show the variety and differences among the types of tools. First, some initiatives are self-regulation. They are created by the financial sector itself. A second set of tools focus on a key financial risk area, for example climate change, and aim to drive companies to disclose climate-related information. The third group includes norms that have been developed by governments to promote responsible conduct and which are addressed at all companies, including those in the financial sector. All these tools and instruments are closely related and intertwined. They cross-reference each other and often evolve in parallel. More importantly, they all contribute in one way or the other to the implementation of the key international agreements driving sustainability, such as human rights law, the Sustainable Development Goals, the Paris Climate Agreement, and other international treaties on human rights and the environment. Let me talk now about the first category of soft law I mentioned earlier, self-regulation. A range of voluntary initiatives are developed or driven by financial sectors themselves, setting out common principles on more responsible practices, for example, for project finance. One of them are the Equator Principles, developed by banks for banks and self-defined as a financial industry benchmark for determining, assessing, and managing environmental and social risk in projects. Another example are the Principles for Responsible Banking, housed by the UNEP-FI, United Nations Environment Programme Financial Initiative. These principles aim to help banks to take action to align their core strategy, decision-making, lending and investment with the UN Sustainable Development Goals and international agreements such as the Paris Climate Agreement. Key features of these instruments are the requirement to request client companies to carry out social and environmental impact assessments and to report on their known and potential environmental impacts, including greenhouse gas emissions. They do not, however, include a commitment by the bank to refrain from providing finance or supporting a project with an actual or potential adverse sustainability impact. The second set of soft law tools is disclosure of non-financial risks. For many years now, one of the most used tools to promote sustainable finance has been to drive companies to disclose so-called non-financial information, aimed to help investors assess the related risks. A good example of how soft law has gradually developed into increasingly harder law is that of climate risk reporting. The financial sector, and in particular institutional investors, has been aware of the risks related to climate change on the value of their investments and assets for many years, and it has been behind the development of a range of incentives for corporate disclosure and reporting standards. One of the first such standards was the Carbon Disclosure Project, or CDP, established in the year 2000 to meet the demand of investors for better disclosure of companies' climate risk-related information. In 2015, the year of the adoption of the Paris Climate Agreement, the Financial Stability Board created the Task Force on Climate-Related Financial Disclosures, TCFD, an industry-led body with a mandate to develop recommendations on the types of information that companies should disclose to support investors, lenders, and insurance underwriters in appropriately assessing and pricing risks related to climate change. The TCFD recommendations saw a significant uptake by companies, investors, stock exchanges, etc. And in 2022, the UK made climate disclosure in line with the TCFD recommendations mandatory, not only for companies, but also for public bodies. The third set of soft law instruments are international principles and guidelines developed by governments, aimed at promoting a more responsible and sustainable conduct by companies of all sectors. One example are the UN Guiding Principles on Business and Human Rights, the UNGPs, adopted in 2011. They are built around states' obligation to protect human rights and enterprises' duty to respect human rights. Another example are the OECD guidelines for multinational enterprises on responsible business conduct, which include recommendations to companies to identify and address their adverse impacts on human rights, the environment, workers' rights, etc. One distinctive aspect of the guidelines is the complaints mechanism, so-called National Contact Points or NCPs, which allows interested parties, including individuals, NGOs, workers' organizations, etc., to report a company's alleged breach of the guidelines. A significant number of complaints submitted to National Contact Points relate to the behavior of financial companies, including major banks. And while the National Contact Points cannot issue fines or penalties, the statements can have significant impact, thus giving teeth to the non-binding guidelines. For example, the outcome of a complaint brought against the bank ING resulted in changes in the policies to address climate-related risks. Another example is a complaint against ANZ Banking Group regarding human rights violations by an investee company, which led to divestment by the bank and a financial compensation of the victims of those violations. Both the OECD guidelines and the UNGPs use key financial terms to define the expected action by companies to reduce the risk of causing adverse impacts. Notably, the term due diligence, typically used in the financial context to identify risks to the company, is defined in these instruments as a tool to identify and address risks by the company to society and the environment. This notion of due diligence is also at the core of the EU Corporate Sustainability Due Diligence Directive, CSDDD, which is in the final stages of formal adoption and is expected to be implemented by EU member countries as from 2027. The directive mandates large companies based and operating in the EU to carry out sustainability due diligence to identify and address adverse impacts that they cause or contribute to throughout their supply chain. Both the OECD guidelines and the UNGPs are good examples of how soft law is the precursor of hard law. Both are also important elements of the EU's Sustainable Finance Action Plan and are embedded in the Sustainable Finance Disclosure Regulation and the Corporate Sustainability Reporting Directive. These are subjects that will be developed further in other videos of this course.